Keeping government and religion separate is a fundamental concept outlined in the First Amendment by our founding fathers. But it has been a hard-fought battle to protect this basic concept, and it was put to the ultimate test as recently as the 1940s. In 1945, Vashti McCollum filed suit against the Champaign, Illinois public school system when her son was punished at school for not attending religious education classes. The suit eventually made it to the U.S. Supreme Court, and McCollum versus Board of Education ended with the landmark decision that religious education in public schools was unconstitutional, fortifying the wall of separation between church and state. Jim McCollum, who at age 10 was the subject of the lawsuit, spoke about the case at an event sponsored by the Houston chapter of Americans United for Separation of Church and State.
My mother was not interested in attacking people's religious beliefs. She just felt that sectarian religion does not belong in the public schools. The public schools belong to everybody, as she says, not to a particular sect. The first issue we had to overcome before the U.S. Supreme Court was standing. You have to have standing to sue. You can't just say, I object to something and sue in court because you don't like it. You have to have standing, which means you have to have some sort of a personal connection with the issues and the situation. Mom was able to acquire standing by virtue of the fact that she was a taxpayer, and probably also because of the indignities that we were being subjected to at the time. And I suspect that probably is what carried the day in front of the Supreme Court. Neither my brother Dan nor I had any doubts whatsoever that we were right. We never had any feelings of animosity towards my mother for bringing that case. The hassles that I particularly went through were just part of what you had to go through in order to accomplish something. I remember telling my mother when we lost before the circuit court and we're losing in front of the Illinois Supreme Court, or she'd just gotten up there, I guess. I said, well, I hope we lose in this Illinois Supreme Court, because then it'll go to the U.S. Supreme Court. If we win in the Illinois Supreme Court, it'll be law in Illinois. If we win in the U.S. Supreme Court, it'll be federal law. That was when I was 12 years old.
Could you explain to us how a case law that's established in this manner can be just consistently and continually ignored 10, 20, 30, 40 years later?
Anybody recognize the name of Ray County, R-H-E-A County, Tennessee? The county seat is Dayton. That's where the Scopes monkey trial was tried. 50 years to the year of the decision in the McCollum case, the exact same case was raised in Ray County, Tennessee, regarding students from the William Jennings Bryan University teaching religion classes in the public schools. This is the first time in the history of the United States where we actually have a religious-based political party. And it certainly has been particularly evident in this particular campaign, especially with the likes of Rick Santorum, but also your own governor and others. Introducing religion into politics, introducing it into the schools, is divisive and just has no place in those forums. Wendell Phillips, I believe his name, coined a phrase, the price of liberty is eternal vigilance. It's been ascribed to Jefferson, but it's Wendell Phillips, who was an abolitionist. And that's true of any constitutional right.
Jim, thank you very much.